extend a warm welcome to the 5th edition of FICCI Dialogue for Actionable Insights. FICCI has been doing these dialogues for quite some time, and we feel instead of long speeches, when pointed questions are posed and answered, there will be good insights coming for action. I take this opportunity to extend a warm welcome to the Honorable Chief Justice Buyan. I also extend a warm welcome to Justice Nageshwar Rao, former Judge of the Supreme Court, and I extend a warm welcome to all of you. The topic is of great importance to all of us in general and to the business in particular. ADR, Alternative Dispute Resolution, has been recognized as a wonderful tool to resolve disputes in an informal way, at a low cost and extraordinary speed. In India also, we have been grappling with this concept for quite some time, starting with 1940 Act and now 1996 Act and amendments thereof. In spite of noble intentions that ADR should resolve the disputes in a quick manner, the results have been otherwise for various reasons. In India, we all look to judiciary with great hope, and we have great trust in our judiciary. Our judiciary has been rendering yeoman service to our society in spite of great odds. Just a few minutes back, we were talking about in the back room that huge frivolous legal litigation is clogging the courts. You can neither say, don't file it, nor say, come and file it. It's a sort of debilitating the system. Once Justice Desai lamented in one of his celebrated judgments on arbitration that instead of being a boon, arbitration has become a bane. It's my personal experience that some of the arbitration awards are meandering through the courts for at least 2 decades. I at least know 1 or 2 cases which are languishing in the courts for 2 decades. This is definitely not the intention of the judiciary nor the legislature. In this context, we thought this dialogue will throw light on how to make ADR effective so that business in this country grows. All of us know conflict resolution, dispute resolution is very much essential for the growth of business. When business grows, employment grows, taxes grow, and prosperity comes to society. That's where it is not as though dispute resolution is an esoteric concept confined to the halls of justice, but it affects all of us. In that context, we have 2 legal luminaries here who have kindly consented to be our guests. In spite of their busy schedules, they have come here. We look forward to them to show how ADR can be made effective in resolving the disputes in a quicker fashion, in a scientific fashion, in a fair fashion, so that business in this country grows and prosperity comes to society. And it is not an exaggeration to say GDP depends to a large extent on quick resolution of disputes, particularly commercial disputes. With these words, I extend once again warm welcome to our legal luminaries and other dignitaries, and it's going to be a wonderful session, and we look forward to these two legal luminaries showing us the way forward on making ADR an effective tool in promoting business. Thank you very much.
So good morning everyone. It's with immense pleasure that we welcome all the dignitaries and the delegates to this conference on alternate dispute resolution in the context of ease of doing business, because this is, I congratulate FICCI and IAMC for, sponsoring this very interesting a topic which is of great significance in today's world, because as all of you know, the Indian economy is doing very well. The macroeconomics and the fundamentals of doing business in India are pretty strong. India is on a high economic growth trajectory and is a preferred destination for global and international investments. In that context, I also take the privilege to give some introductory remarks. But firstly, I wanted to thank the distinguished dignitaries, Honorable Mr. Justice Ujjal Bhuyan, Chief Justice of the High Court for the State of Telangana, and Honorable Mr. Justice L. Nageshwara Garu, former Judge, Supreme Court of India, for sparing their valuable time and agreeing to preside over the session and share their valuable insights on this topic of great significance. It's been a positive aspect that despite the pandemic and the global developments that are happening world over, India received the highest annual FDI inflows of USD 84,835 million in financial year 21-22. This is much higher than what the FDI was received in the previous years. Earlier FDI inflows were 74,391 million. And it may be noted that as per the Ease of Doing Business Index, the United Nations Conference on Trade and Development World Investment Report 2022, in its analysis of the global trends, India has improved. This is regarding the FDI inflows. It's one of the 7th ranked in the world. It's one of the top 20 host economies for receiving foreign investments into India. And the government has implemented several transformative reforms, as we all know, in terms of GST, ease of starting new businesses, dealing with construction permits in a different way, trading across borders, resolving insolvency through IBC. Some of these factors are step in the right direction. And in terms of ease of doing business, India is ranked now in 63rd among the 190 economies in the world, according to the latest World Bank annual rankings. This is an improvement from where we were 142 in 2014. Therefore, there has been a lot of improvement in the ease of doing business. However, I think the country, India, continues its lackluster performance under the contracts enforcement category. In the enforcement of contract commercial disputes, we are way behind, and our ranking is 163rd amongst the 190 countries, and it is one of the lowest among G20 countries. According to the statistics, it takes almost 1,445 days, almost 4 years, and the cost of litigation is around 30 to 40% of the claim value is lost by the time you have a resolution at the local first instance court. And this does not take into consideration the time lost in appeals and until the final resolution. This is almost 3 times the average of what the time that is taken in OECD and other G20 countries. This is where I think there is a significant attention that is required. And if the cost exceeds the profits under the contract, the enforcement process becomes a value destroyer instead of a value creator. Comparatively, in terms of the dispute resolution timeline and cost, it takes around 164 days. that is less than 5.5 months, around 6 months in Singapore for contracts enforcement. And it is about 10% of the claim value that is lost in the costs of the enforcement. So this is again, the picture is much better in the other countries like Luxembourg, Norway, and a few other jurisdictions. And according to the latest data published by the National Judicial Data Grid, almost 2 crore cases are pending in the district courts, 1/3 of which are all civil cases, commercial disputes and civil matters. And the number of civil cases being filed has drastically reduced in the recent past, in the last decade, which is not a good sign. And I think people are pretty much resolving to the criminal justice system, I think giving the garb of a criminal issue in a civil dispute for faster resolution and faster enforcement of the contract matters. Therefore, alternate dispute resolution through mediation, conciliation, arbitration becomes significant. It's the need of the hour for the resolution of commercial disputes. An effective ADR process will go a long way in improving the business environment, in giving further stability, and in increasing the credibility of the dispute resolution process in India. I'm sure many lawyers here will agree, and not just in the domestic front, but also for lawyers, some of us who are practicing also on the international front, it's a battle we fight almost every day. When there are clauses in some of these complex commercial contracts relating to arbitrations which are put in, the general perception is that people in India arbitrate and then litigate. So arbitration is not a finality of a proceeding. People arbitrate, then go file cases in the courts, and it's a parallel proceeding. Arbitrate and litigate is the perception. Therefore, when you're negotiating with global lawyers on the other side, the dispute resolution clauses invariably go out of the Indian jurisdiction. People prefer to have Singapore International Arbitration Center or London ICC or the American Arbitration Association. It all depends on where the jurisdiction is, but general preference is to have dispute resolution outside India. And that is a loss to the legal community, to the economy, and to all the arbitrators and all the experts who are practicing in our country. And that is something I'm sure Justice Nageshwara Garu and Justice Bhuyan will address in this conference. I just wanted to take 5 minutes just to dispel certain notions. The Arbitration Act is one of the legislations which has gone through significant changes from 1940 until now 2021 also. Multiple amendments, multiple changes have come about only to make the process more efficient, cost effective, expeditious. There are multiple features, and that shows the policymakers have been focusing on this area. There is very good attention. You'll see that there has been good improvement. And as you all probably know, the 1940 Act was repealed, and that in the light of the economic liberalization in 1991, and we have adopted the UNCITRAL model of law in international commercial arbitrations. Now both the 1996 Act was a good step in the direction. It dealt with both domestic and international arbitrations in India. However, there were quite a few lacuna in the working of 1996 Act, and then the 2015 amendments came in, where there has been a time period fixed for arbitration awards to be passed, 12 months from the time of the constitution of the arbitral award, and also interference by the courts under 34 was curtailed. The public policy jurisprudence in terms of interference, courts used to interfere. It almost was like an appeal when you go to the court, though I think section 34 had limited grounds on which you can challenge. The judicial interference was more rampant earlier, but now the 2015 amendment has also clarified what constitutes public policy. Only if it is a fraud or a corruption, or if it is in contravention of the fundamental policy of India, or if it is in conflict with the most basic notions of morality or justice. So it has been a limited grounds for interference as well. So there have been multiple initiatives, and subsequent amendments in 2019 also brought about, because the policymakers have seen that even the appointment of arbitrators is taking time. It probably takes, not just in our high court and other high courts as well, it is taking around 2 to 3 years for the appointment of an arbitrator, in case the parties are not able to agree on the appointment of an arbitrator. So section 11 petitions were also taking time. Therefore, the legislation has in its amendment brought about the power to delegate this to an arbitration council of India and other arbitral institutions where you could approach instead of just the High Court or the Supreme Court and seek for appointment of arbitrators. And that could happen within 60 days and the time periods are provided for. Though I think some of these provisions are yet to be notified, but at least it's a step in the right direction. And I would also want to emphasize that now with the International Mediation and Arbitration Center in Hyderabad taking up, we are competing with the likes of Singapore, Hong Kong, where they have been established for a long time. There has been significant support from the government. In fact, in the SIAC, government were the shareholders for a long time, and there was a lot of support to promote international arbitrations and make Singapore a destination globally for international arbitrations. And I think that is where we need to aim or promote our arbitration regime. It's not just make in India, but arbitrate in India and get the resolution of the disputes should be where we should be headed.
Honorable Mr. Justice L. Nageshwar Rao, former Judge, Supreme Court of India, Mr. Murali Krishna Reddy, Chairman, FICCI, Telangana State Council, distinguished dignitaries on the dais, retired judges, senior advocates, all distinguished members of the gathering, friends from the media, ladies and gentlemen. A very good morning to all of you. And I'm really delighted to have been invited and taking part in this dialogue initiated by FICCI in coordination with the International Arbitration and Mediation Center, Hyderabad, on the topic of importance of alternative dispute resolution from the perspective of ease of doing business. Friends, when we say alternative dispute resolution, the normal ordinary meaning would be that it is a system which is alternative to the existing dispute resolution system, meaning thereby the court process. Ordinarily, when we refer to or speak about dispute resolution, we mean the adjudicatory process which takes place in the court. Being adjudicatory, it is mostly adversarial in character. From the Indian perspective, adjudication is multi-layered and consequently has a long lifespan. It is often said that the wheels of justice move slowly but surely. So we have this adjudicatory system in place, the court system in place, which has now become really overburdened. In the 1970s, I remember Pritish Nandi was the editor of Illustrated Weekly of India. It was a very popular magazine at that point of time. And I distinctly remember a photograph there saying a lady from Punjab carrying about 15, 16 bricks on her head and still managing to smile. That's the Kushwant Singh in his inimitable style put it that way. So I would just like to add, if you put one more brick on her head, she may still be able to walk, but I don't know whether she will be able to smile. You add one more brick, then certainly she will wobble. And if you add one more brick, there's every possibility that everything will fall down. So every system has got an inherent limitation, There are certain things which are beyond our control. It's beyond the judiciary, the population, the huge number of litigation. Indian litigation in India, therefore, qualitatively or quantitatively cannot be compared with other jurisdictions. It's a huge country, a huge population. There's more and more awareness about rights. We can't tell the people, don't come to the court. In fact, we should tell, please come to the court if you have a grievance, get it settled. But therefore, this is really, it's becoming a problem, the overburdening or the overflowing of litigation in the courts. But one thing is very certain, that by and large, adjudication in India is fair. Nobody can, even the worst critics of Indian judiciary also will not be able to say. By and large, it is a fair, very fair process. Any businessman or any other, if you give them an opportunity, whether you want to settle your dispute in India or maybe in China, I'm told it's over by 21 to 30 days time, the dispute is resolved. Whether you like to have your dispute settled there or in Russia, I'm sure most of the people would like to settle their disputes in India. So, from the perspective of business or industry, what I can understand is that there are certain basic things which industry needs or business needs. One is obviously, since it is business, commerce, industry, dispute is inevitable. Some are institutional disputes, some are inter-party disputes. So, the legal system must provide for an effective, assured and a speedy dispute resolution. Most importantly, there must be certainty in the legal framework. In other words, business or industry will look towards a scenario where there is certainty in the laws and the uniform application of the law, procedure-wise also. It cannot happen that based on the existing laws of today, a foreign investor comes to India, sets up a business. 5 years down the line, another law is brought in, which adversely affects the interest of the investor, and it's given retrospective effect. These, of course, these are outside the scope of the judiciary, but then again, this is a very important aspect. The certainty of the laws, we can't have frequent changing of the laws and then make it applicable retrospectively to affect existing business. Again, timely resolution of disputes. Natural corollary of the above is that it must be a fair process. As I said, our judicial system is overburdened, rather overflowing with litigation. There are multiple reasons for this. It is not a forum to discuss. As an alternative to the court system, we must have parallelly an alternative system of dispute resolution. So when we say ADR, it does not necessarily mean arbitration alone. Arbitration is only one of the modes of alternative dispute resolution. There are various other facets or modes of alternative dispute resolution. It is not that only after section 89 came into the civil procedure code that we have statutorily recognized different modes of ADR. If you look at the Industrial Disputes Act 1947, this is an act to ensure industrial peace and harmony in the industrial sector, that there is peace and harmony between the management and the workmen, so that there is increased productivity. Before a reference is made under section 10, there is provision for conciliation. So in 47 itself, this concept was visualized, that you go for conciliation. There is a provision for conciliation officer, there is provision for conciliation board. And if the conciliation succeeds, there's nothing like that. If it fails, the conciliation officer will send a report to the appropriate government. Appropriate government will then make a reference under section 10 to the labor court or the industrial tribunal. So then section 89 has been introduced in the CPC. I need not elaborate on this. We have arbitration, we have conciliation, we have judicial settlement of disputes, including through lok adalats, and then mediation. There are judgments of the Supreme Court explaining the concept of ADR. I need not again go into all these aspects. Salem Bar Advocates Association, then again AFCONS also. Then in statutes like Micro, Small and Medium Enterprises Development Act, MSMED Act 2006, we have an inbuilt provision for dispute resolution. Section 17 deals with claims. 18 says that if there is a dispute as to the claim, non-payment, etc., then you make a reference to the Facilitation Council established under 18. Facilitation Council will first explore conciliation. If conciliation fails, then it will refer to arbitration. So this again, it is not that they can go parallelly, side by side, conciliation and mediation. If it is conciliation, then sections 65 to 81 of the Arbitration and Conciliation Act 96 would come into force. Otherwise, if it's arbitration, then provisions of the 96 Act would follow. Then in 2015, we had this Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015. By way of amendment, it is now known as Commercial Courts Act 2015. Now, this Act defines what is a commercial dispute. And Chapter 3A was brought in later by way of amendment, containing only Section 12A. And it says that in case of a suit which does not contemplate any urgent interim relief under the Commercial Courts Act, the same shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation. So therefore, mediation has been statutorily recognized in the Commercial Courts Act 2015 in terms of Section 12A. And before the central government has to notify the authorities before whom mediation is to take place. And the period spent in mediation, successful or otherwise, will not be counted in terms of the Limitation Act. Then again, the Section 10 of this Act provides for arbitration. So we have statutes which parallelly allows arbitration as well as mediation. Friends, as has been pointed out in the welcome by our moderator, arbitration has now become an established and recognized mode of ADR because of its widespread use and acceptability in the commercial world. It has become a virtual parallel process of adjudication. Once it is referred to arbitration, it goes out of the legal system. Unlike the other modes of ADR, for example, mediation or conciliation or lok adalat, once it goes out to this forum, it will have to be sent back to the court for a decree in terms of the settlement arrived at between the parties. Even if it fails, it will again go back to the trial, the courts for dispute. But once it is sent to arbitration, of course, with the consent of the parties, it goes out of the judicial system. Arbitration is successful, but the grievance against arbitration, as was pointed out, is that it has become very expensive, and secondly, it has partaken the character of a court proceeding. Like a court proceeding, there is multi-layered. The arbitration decree is not enough. It is the beginning of the process. The effectiveness of the arbitration awards. Though amendments have been brought in, a lot needs to be done. A lot of awareness needs to be created. Section 34 is there. Many a court, they treat Section 34 application like a very appellate proceedings, and then they examine the award passed by the arbitrator. And despite Supreme Court saying that on matters of fact, the award passed by the arbitrator in the arbitration proceedings should be treated as final. Unless there is absolute perversity, don't interfere, but still interference is taking place. This is an area where something needs to be done. I'm sure it will be done in due course of time. And then arbitration in India again is an issue. Though we have this center here in Hyderabad, International Arbitration and Mediation Center, most arbitrations in India are done by retired judicial officers and retired judges of the High Court. Then we need to actually have a trained pool of arbitrators who can handle specialized arbitrations which are there today. Finally, this mediation, it is catching up. Mediation is a voluntary process. I need not elaborate on this aspect. It is a voluntary process. The trained mediator who has undergone mediation training under the mediation and committee of the Supreme Court for 40 hours, mediation and conciliation project committee, MCPC of the Supreme Court for 40 hours, and has also successfully conducted 10 actual mediations, then he becomes a mediator. So mediation is a very informal kind of a dispute resolution process, where the mediator will facilitate. He acts more like a facilitator to bring the parties to the dispute closure. The resolution of the dispute lies in the hands of the parties. Therefore, complete party autonomy is there insofar as mediation is concerned. All that the mediator does is to create a conducive environment for the disputing parties to work it amongst themselves, the best possible solution which can come. Because business has evolved in our country, a prudent businessman, a seasoned industrialist knows to what extent his claim is tenable in law. So, therefore, in the mediation process, guided by the mediator, the conducive environment created by the mediator, I am sure this is the parties are able to reach settlement. So, mediation is on the upswing. Of course, there is a long way still to go, and there are places where mediation and arbitration go hand in hand together in several jurisdictions. We can also explore it. It is not that mediation is or arbitration are exclusive to each other. As I had said at the introductory stage, business or industry needs an assured fair certainty in law and a relatively quick disposal mechanism which has an element of finality. A lot of ground has been covered over the years, but a lot still needs to be done. I am sure with conclaves like this, we will be able to dispel many cobwebs which have blurred our thought processes and also give us valuable inputs and suggestions as we move ahead. We have Justice Nageshwar Rao with us. Certainly, I am also looking forward to hear from him. With these few words, I am of the view and I pray that the purpose for which this dialogue has been organized today will achieve its result, and wishing the organizers the very best. Thank you very much.
1981, somewhere in September, Justice Desai, when he was dealing with this case, Guru Nanak Foundation versus Ratan Singh, I'll just quote two lines what he said. He said that the way in which the scheme of the Arbitration Act 1940 has been implemented has made lawyers laugh and legal philosophers weep. Now, this was the situation of arbitration back in 1981, which is almost 40 years ago from today. But as I sit here today with you, I think much has changed. We have come a long way, and usually when I used to attend conferences, there were always criticism about arbitration in India. But believe me that no system is perfect, and we need to focus on the possibilities and not the limitation. Coming up with IAMC is one such step where we are trying to institutionalize arbitration in India, owing to various benefits that institutions can provide to any dispute resolution. And I'd also like to quote, I think Sundari in the beginning started from the 1940 Act. I will take you back very briefly to King Solomon. The biblical theory says that King Solomon was the first arbitrator in the world. So arbitration is not a new concept. The very famous story where two mothers were fighting over a baby, and King Solomon said, let's cut them into two pieces. And when the real mother said, no, don't do this, give it to the other one. So that was the first case of arbitration. And arbitration has been there in India also. In 1889, then 1908, Schedule 2 of CPC was dedicated to arbitration, though the first proper law was 1940. I'll give you an example of how a dispute which came to us recently, a commercial dispute where the stakes were very high, two parties walked into IAMC. This was very recently. And they did not know what they have to do with IAMC. People had this presumption that it's an international center, so domestic disputes may not be entertained or it must be too expensive. But like sir already pointed that if you look at our administrative fee as well as the rooms that we are having for conferences, we are trying to make arbitration and mediation more affordable. I look at ADR as affordable dispute resolution, not as an alternative, appropriate dispute resolution, and I want to make it PDR, not EDR. EDR, obviously, sir has very rightly said that's what the expectation is. I want that arbitration and mediation should become a preferred mode of dispute resolution or a primary mode of dispute resolution, at least in commercial disputes. And that is our endeavor. So sir has very rightly given the inputs, both Honorable Justice Ujjal Bhuyan and Honorable Justice Nageshwar Rao. They have been at the forefront and they are some of the finest speakers that you will see in the country. And the inputs that they have given are actually the right problems. So we need to focus on enforcement, yes, that's correct. The other thing is we need to have a dedicated arbitration bar. We need to have full-time arbitration lawyers, because by the time the court finishes, as lawyers, we are mentally and physically exhausted and we can't give our 100% to arbitration. So I think these are few of the things which we must focus on, and I'll not keep it long because I know I am between you and lunch today. But we have a very short film which we have prepared for IAMC for some of you to know, and I'll be very happy to answer any questions after the conference. But we have prepared a short video to show you what exactly IAMC looks like and what we are doing, how we are conducting mediation and arbitration.
FICCI, Hyderabad International Arbitration and Mediation Center తో కలిసి హైదరాబాద్లో ఉన్న బిజినెస్ లీడర్స్ని, ఇండస్ట్రియలిస్ట్ని పిలిచి ఆర్బిట్రేషన్, మీడియేషన్ గురించి మాట్లాడే అవకాశం నాకు చీఫ్ జస్టిస్ గారికి ఇచ్చారు. బిజినెస్ చేయటంలో సులువుగా ఉండేదానికి ఈ ఆర్బిట్రేషన్, మీడియేషన్ ఎలా ఉపయోగపడుతుందనే దాని గురించి 2 గంటల నుంచి అక్కడ డిస్కషన్ జరిగింది. ఈ ఆర్బిట్రేషన్, మీడియేషన్ అనేది ఎందుకు ముఖ్యమంటే, కోర్టుల్లో కేసులు చాలా ఎక్కువైపోయి కేసులు ఆలస్యం అవడం మూలంగా కక్షిదారులకి న్యాయం జరుగుతుందని అనిపించట్లేదు. అందుకని ఈ ఆర్బిట్రేషన్, మీడియేషన్ తోటి వాళ్ళకున్న సమస్యలు తొందరగా పరిష్కారం చేసుకోవడానికి అవకాశం ఉంది. దీన్ని ప్రమోట్ చేసి ఏదైనా డిస్ప్యూట్స్ ఉంటే మీడియేషన్ ద్వారా, ఆర్బిట్రేషన్ ద్వారా పరిష్కారం చేసుకుంటే కోర్టులో కూడా ప్రెషర్ తగ్గుతుందనే దాని గురించి డిస్కషన్ జరిగింది.
Promoting business and also in facilitating policy changes in the government to get ease of doing business. In this context, we thought alternate dispute resolution, particularly mediation, arbitration, will go a long way in promoting business. And we were lucky to get these two legal luminaries, Chief Justice Bhuyan and Justice Nageshwar Rao, to come and talk to us on this subject. And this has been a beautiful session for advocates, arbitrators, and also the industry people. Ease of doing business goes a long way in promoting business and prosperity, and also creating jobs and more taxes to the government. Ease of doing business is in the interest of everybody, is in the interest of common man, is in the interest of society at large. And FICCI has always been working hard to facilitate policy changes to see that doing business is smooth affair without much hindrances. Thank you.